action admissions policy. The judge is here straightening me out and everybody else. All right.
As best I can,
now,
not having seen the opinion.
You haven't seen, but you've read the summaries.
Yes.
Okay.
Yes.
Now, the white student complained and took it all the way to the Supreme Court saying, my race was a factor in me not being admitted to your university. You can't do that.
And Texas admits to that. So when the Supreme Court says send it back for a jury trial, my question is, a jury trial on what? The state of Texas admits that it made a decision based on race. It says that there are good reasons for it. It says that its reasons are the diversity of the makeup of the student body. Where did they get that from? They got that from the last time the Supreme Court looked at this in 2005 in a Justice O'Connor decision involving the University of Michigan.
Don't confuse me, Judge. So the Supreme Court did not say today, they did not say, hey, you, University of Texas, you can't do that.
No.
They didn't say that.
They did not say that. So this is an ungratifying opinion, both for the plaintiff who wanted the Supreme Court to say no state may make a decision based on race, and for school administrators and state officials who want to be able to make decisions based on race for what they say is a greater good of diversity of a student body.
What happens now? It goes to some jury trial?
Yes, it goes back to a district court judge in Texas for a jury trial in which the plaintiff will put Texas officials on the stand who will admit that they made a decision based on race, and then the plaintiff will ask the judge to tell the jury, well, we don't know what. That's where it ends. That's where it's inscrutable, because these Michigan decisions involving the University of Michigan just 10 years ago say you can make a decision based on race, but only for the next 25 years. Where did the 25 years come from? Nobody knows. Justice O'Connor made the number up.
Why did the Supreme Court duck? Why didn't they issue a ruling and say, you can do this or you can't do that?
Stuart, I am as frustrated as you are. I'm frustrated for a couple of reasons. One, the legal community and the judicial community needs guidance. Can state officials make decisions based on race, or can they not?
But I thought that decision was already decided years ago, decades ago, by the Bakke decision, in which there were set-asides, 16 seats for minorities out of 100 seats, and that was ruled unconstitutional.
You could argue
correct?
that decision was made in 1865 when the North won the Civil War, and in 1868 when the 14th Amendment was added.
We're talking 1978, which is the Bakke decision.
Correct.
Where set-asides for minorities were ruled unconstitutional.
That decision was tampered with by the Grutter decision, the Michigan decisions, which basically said you can use race for the higher good, but only for 25 years.
This is a huge fudge.
Yes.
Today, it is a fudge. We do not know.
This
now,
is not what the Supreme Court is supposed to do. It's supposed to give guidance as to what the law means, not punt.
It was a 7-1 majority opinion. Justice Kagan
recused herself. I don't know who the dissenter was.
Justice Ginsburg. She was the dissenter. I mean, can you read anything into that? Or no,
no, you can't read into it. But I pity the trial judge who has to tell the jury what the law is. What does he say the law is? Is it the University of Michigan case? Because if that's the case, then there should be no case. Or is it whatever is in this Texas opinion, which is a punt?
Don't we have a Supreme Court to decide these things? Lay down the law.
Yes, we do. There's an old one-liner. The Supreme Court is infallible because it's final. When it doesn't give a final decision, it loses.
By the way, if this was a private institution, would it have been a different case entirely?
Yeah.
I can't give you a straight answer. If they accepted federal funds, then they cannot discriminate on the basis of race. If they are truly, truly private, like Hillsdale
College.
Yes, they can.
Okay. So they punted on Obamacare. In fact, the Chief Justice came up with his own reason why Obamacare was okay, didn't he?
Well, I wouldn't call that
punted on affirmative action?
I wouldn't call that a punt on Obamacare. They came down, regrettably, in your view and mine, on the side of it. They found a specious reason for it, but they upheld it. But they are not giving gratifying answers. But before we criticize them wholeheartedly, we have some major cases coming in the next 2 or 3 days, and you may be happy or displeased with the outcome, but I think you'll see some certain answers in there. Just a guess.
You will be here to tell us what we ought to know about these decisions, because it's voting rights, and there's another one on
DOMA and gay marriage.
Gay marriage. Okay.
Yes. Yes.
So you will be here.
I'll be wherever and whenever Mr. Varney wants me.
Be very careful.
And there's an hour extra of that starting today.
You can sleep in late.
How's your energy level? Good.
We're not doing too badly, actually. Yes. I could use some coffee, and I'm going to get some, too.
See you in an hour.